It was crazy. But as you were ending and, you know, I had just gotten the findings, I was like, you know what? This is the most appropriate time to read them. So I figured, let's just do it.
Absolutely.
All right. So are you guys ready?
Ready. Here we go. Ready as we'll ever be.
All right. So it says findings of fact, analysis, and conclusions of law. 1. The parties both operate YouTube channels that focus on the true crime genre. In April of 2021, respondent participated in an online panel with petitioner. Respondent subsequently contacted petitioner concerning a case petitioner was featuring on her YouTube channel. Over the next several days, they sent communications that were flirtatious in nature. Respondent also sent petitioner a video in which she appeared topless. On May 21st, 2021, petitioner informed respondent she was not comfortable engaging in such further contact. Petitioner felt guilty because she was beginning a relationship with someone else identified as Allie. Petitioner shared the parties' messages with Allie. Respondent learned that petitioner had disclosed their communications, including those containing sexual content. 2. This then led to respondent participating in an online forum that the parties referred to as the Sex Panel. The Sex Panel was organized by Natasha Cooper. According to petitioner, approximately 16 victims participated in the forum and made salacious accusations against her, including falsely alleging that she was a sexual predator. Respondent testified that she was hearing from others about things petitioner was doing, including that petitioner was pitting YouTube creators against each other. Respondent participated in the Sex Panel because petitioner had shared nude images of her. She denied that she accused petitioner of being a sexual predator. 3. However, in June of 2021, respondent apologized for participating in the panel, though she maintained that everything she said was truthful. Petitioner accepted her apology, telling respondent that she wanted to get to the bottom of who set it up. 4. During this time frame, petitioner was starting to put the pieces together that she was being targeted by several individuals who were all connected. Petitioner testified that multiple women had direct messaged her, sexually baited her, and then engaged in blackmail. She believes that other YouTube creators were jealous because she was quickly generating a following, and they wanted to sabotage her. Petitioner accepted respondent's apology. Petitioner then spent the ensuing months continuing to develop her YouTube channel, investigating who was targeting her, and trying to clear her name. 5. Throughout 2021 to date, petitioner continues to have issues with multiple people who she alleges are extensively trolling and harassing her, trying to harm her business and personal relationships, and to impact her mental well-being. Notably, in 2022, Vanessa, who operates a YouTube channel Unmasked, was granted a protection order against petitioner by a Colorado court. Petitioner was not successful in seeking her own order of protection against Vanessa in this court, but petitioner did obtain a protection order against YouTube creator Aunt Lala. 6. Turning back to respondent, the parties agree that their last direct interactions occurred in late 2021. However, in the spring of 2023, petitioner was given a copy of a private group chat between respondent, Aunt Lala, and another individual, Andrea Powers. These individuals conversed extensively about petitioner from January through May of 2022. Much of petitioner's evidence focused on respondent's conduct in 2021 and the statements made in the 2022 group chat. Petitioner exhaustively cross-examined respondent on these issues. Petitioner sought to prove that respondent remains heavily involved in an ongoing scheme to harass, discredit, and ruin her. Petitioner accused respondent of engaging in or being responsible for third-party harassment. 7. What petitioner failed to do was present sufficient evidence that she presently is the victim of conduct that rises to the level of menacing by stalking. Proving that respondent may have participated in such acts in 2021 or 2022 would not warrant the issuance of a protection order at this time. This is because a protection order is not punitive, but rather is issued to provide safety and protection. However, the circumstances must show a likelihood of future misconduct absent the issuance of a protection order. The recent case of Tucker versus UHL is highly instructive. The next three numbers reference that case, so I'm just not going to get into that. And so number 11 goes on to say, here, respondent and petitioner last communicated at the end of 2021. Respondent credibly testified that she is not engaging in conduct to interfere with petitioner's personal life or business or her professional business. Respondent admits that she privately speaks to other individuals about the ongoing dispute and rivalry between all the players. But petitioner did not substantiate that respondent is acting in concert with these people or inciting them to engage in harassment. Moreover, petitioner primarily presented conclusory evidence as to the current incidents. She did not substantiate that the conduct met the legal definition of menacing, nor did she sufficiently connect respondent to the events. For instance, petitioner proved that respondent gave James access to the private group chat. James subsequently used a photograph that someone had taken of petitioner during the Colorado court proceeding to create a meme contest mocking her. Because this photograph had been uploaded in the private group chat, petitioner speculates that this is where he obtained it. James' posting of the meme is likely protected by the First Amendment. Regardless, the evidence does not establish that respondent acted in concert with him or encouraged his actions. Respondent credibly testified that she does not agree with everything James does, but he is nonetheless her friend. 12. Notably, petitioner herself is conflicted about respondent's true role and involvement, and she presented varying theories regarding respondent's participation. At times, petitioner suggested respondent was also a victim. Petitioner implied that she would dismiss this action if respondent admitted that she had been fed lies about petitioner by other individuals. But petitioner also alleged respondent was doing the bidding of others to curry favor with them in the hopes that they would help her develop and grow her own YouTube channel. Yet, petitioner claimed respondent's lies and manipulation set into motion the coordinated campaign of harassment and that everyone is essentially acting at respondent's direction and control. Petitioner was all over the place in presenting her case and seeking to establish why a protection order would be issued. 13. Petitioner showed that in 2021 and 2022, respondent engaged in conduct that petitioner finds to be offensive, vexing, and harassing, and that respondent remains friends and is affiliated with other individuals who continue to harass her. Respondent proved that she regrets participating in the sex panel, wants no contact with petitioner, and is not actively interfering with petitioner's life, nor encouraging anyone to do so. The magistrates find petitioner has not established that a protection order is necessary, and that order needs to be put in place to ensure her safety from the respondent. Petitioner failed to present evidence of a recent pattern of incidents involving threats or violence or other acts by respondent that knowingly caused the petitioner to be in fear of physical harm or mental distress, and that are actionable under RC 2903.211 and another one, and the petition is therefore denied. And then there's an adoption of decision and order by the judge who presides over that says the full hearing proceeding was referred to the undersigned magistrate. The court has reviewed the magistrate's decision and finds no error of law or other defect evident on the face of the order, and accordingly, the court adopts the decision as its own, and the petition is hereby denied.
Oh, you mean LO is a lahooser? Okay.
Yep.
Denied.
It just reminds me of like that Billy Madison scene where it's like after all of that incoherent rambling, you know, it's, oh my God. And I really was worried there for a second because how the magistrate was handling it.
Right.
I just felt, because I expected it from her. I was prepared for her. I wasn't prepared for the magistrate, honestly. And so it was very stressful, but
well,
the truth.
I don't think really, I mean, there's a lot of people who said, just go ahead. Why don't you just go ahead and take it? And I even joked,
no,
like, but I don't think people realize if you just go ahead and take it, what it will cause in your life, and what you have to do and what you can and can't do. I don't think people realize how big of a deal those are.
Well, and I think what people have to realize is that she wins even though she loses. She wins because I have not spoken. This right here, this is huge for me. I do not speak about this. So even me getting up here, even me making a comment in your chat, this is more than I've done in a long, long time. And so she wins even though she loses because 2 years I haven't spoken about anything. And so it felt like that just went down the drain, and I was getting mad at the magistrate because it's like, hey, like I put in a lot of work to be quiet and avoided all of this and everything she's always wanted to ask, everything she always wanted to know. She now 14 hours, like of all that she got what she wanted even without getting what she wanted. So she won and she gets to use it, and so she's just going to use it to further harass and to even be forced to have to put people's real names out there. The magistrate was overruling my objection for relevance. She doesn't understand. You are making me put people's names out there that is going to cause them to be harassed. An innocent screenshot that they provided to me to help me,
Right.
Hey, I grabbed this for you. You do not understand that you are putting them in harm's way. And it really sucks. And I really just hope that if anybody lands themselves in the courtroom, which they will, it's just a matter of time, that they won't suffer the same fate that I had to suffer and people before me had to suffer, because that was brutal.
Yeah, I'm actually going through something similar. So
yeah, I wish you all the best with it.